Welcome back to the channel, guys. My name is Nick, and in today's video we'll be going over a few legal strategies to help with debt. So before we get into it, I want to remind you guys this is not legal advice. These are just options that you can use, that you can possibly consult with your attorney or your legal counsel and see what works best for you. These are just ideas that you may have never heard of that could spark some type of solution for you in your situation. So without further ado, let's go ahead and get right into it. So number one, so for an unmarried woman, get married. After you are legally married, you can place your assets in your husband's name and protect their seizure. Basically meaning nobody can take them. We are not suggesting that you take such a step lightly, but if a wedding is soon, adjusting the date to help your financial and legal situation could do no harm. So when you place your assets in your husband's name, they are now become his assets, and they cannot take them or seize them from you if you are in some type of situation where you can get your stuff took. So that is for unmarried women. For a married man, it's basically the same thing. Transfer your assets to your wife. It's a legal fact of life that assets in a wife's name cannot be executed upon because she is not legally responsible for her husband's debts. All right, let's keep it moving. For married couples, move to a community property state. A husband's or wife's creditors cannot lay claim to the couple's community property. Community property states include Arizona, California, Idaho, Louisiana, Montana, Nevada, New Mexico, Texas, Washington, and others. Transfer assets to your small corporation. Since your corporation is a legal entity, a creditor cannot touch your assets once you have transferred assets into it. This is a very good maneuver since small corporations can be formed quite easily. So this is a very, very, very strong. I honestly recommend this for anybody to get a small corporation and start placing your assets in the small corporation, simply because the corporation is separate from you. It is not you. It is considered a totally separate entity from the person in which you are. So when you place the assets in a corporation, they belong to the corporation, not to you as an individual. So therefore, anything that you as the individual, get in trouble for or have legal troubles with, your assets are protected because they are held by the corporation in which you control. So this stems from the own nothing, control everything. That's basically what that means. So let's keep moving. Homestead your house. Homesteading your house is a very simple procedure that will protect you from creditors taking it to settle debts. The protection of having a homestead is not automatic, although it is very simple. You may obtain the necessary forms from your county clerk. In most states, you must fill in the forms, have them notarized, and then filed at the county courthouse. In bankruptcy proceedings, homesteaded property is exempt from creditors. So again, guys, do your own research, look further into this. This is a very powerful method as well. File a denial. If you are served with a summons on a debt, it might be a good idea to file a general denial. Without this, the creditor is almost assured of victory and the power to seize your assets. A general denial simply informs your creditor that you are going to put up a fight. A legal fight can be long and expensive. Many times, the collector will just drop the suit, especially if the debt is less than $500. The procedure for filing a general denial is very simple. Go to the civil courthouse, give it on the summons, give the clerk the summons and say that you want to file a general denial. It's that easy. So a lot of these processes are super simple, guys. We're just not made aware of them. So, if this is your situation, this could possibly be a solution for you. So let's keep moving. Use the Uniform Commercial Code, UCC. You can contend that a contract is unconscionable. That is to say, the contract is deceptive or tricky in language, has important sentences buried in the fine print, was written in language you did not understand, misrepresented the product or service, or was priced unfairly. If any of these has validity, you may have debt discharged. So the UCC is a very, very, very powerful thing, guys. In one of our previous videos, we talked about the UCC 11, where you can go ahead and actually look up debt, and this goes hand in hand with what we're talking about here. So let's take for a car example. Or like a car loan, for example, when you go get a car loan, right, they're supposed to register it with the UCC because you technically, allegedly owe them debt. But since we know debt is not real on this channel, and they do not do that, they skip that step, you never get it never gets filed. So when you do a UCC 11 search, go check out the video where I break that down. You're searching for any debt under your name, it comes back as no debt under your name, even though you may have a house, or even though you may have a car loan, or whatever the case is. The UCC came back and said there was no debt. So you could always use a UCC 11 to actually enforce what you are trying to say. And the Uniform Commercial Code is a very large code base. I suggest everybody do further research on that and find what works for you. So let's keep it moving. Challenge a default judgment. It is almost commonplace for the creditor to win a default judgment without the debtor even getting a summons to appear in court. If this happens to you, you can challenge the default judgment. Write to the creditor telling him or his attorney you intend to bring legal action against them if further action is taken. Since the judgment has been obtained illegally, send copies of the letter to the Attorney General of your state, to the judge of the civil court where suit was filed, and to the local bar association. So this is another option on the table for you guys if you have ever received a default judgment. Wait out the statute of limitations. If your delaying tactics have been successful, your debt may be discharged under the statute of limitations. This is to a period of 4, 6, or 8 years, depending on your state. When the debt has exceeded the time period applicable to your state's statute of limitations without you making a payment, you are no longer liable for the debt. Usually, if you have not paid in 4 years, your creditor has given up the fight anyways. All right, let's go ahead and keep moving. Your rights as a serviceman. So anybody in the military, currently active duty. The Soldiers and Sailors Civil Rights Act mandates that if you are a serviceman deployed for combat, A, your wages are exempt from garnishment, B, you are protected from eviction, and C, you may have any suit stayed upon request. The collector must then prove your military service does not interfere with your ability to defend the suit. A hard task indeed. So any military guys watching this can be to a great benefit of you if you're dealing with anything, any legal matters with debt or things like that. All right, so file a wage earners plan. Chapter 13 of the Federal Bankruptcy Act is especially designed for the debt relief of wage earning individuals. Anyone earning a living from wages, salaries, or commissions can apply for this plan. Although the wage earners plan is often called Chapter 13 bankruptcy, it is not really bankruptcy. The little-known federal law can stop all your creditors in minutes. Under the wage earners plan, you turn all your debts over to a federal court. The court takes a portion of your income to pay your creditors. The payments are usually spread over a 36-month period. This plan is a debt consolidation under court protection. The court protects you from the wage garnishment and other seizures. The only drawback to this plan is that most of your creditors must approve this plan. This may not be such a large concern, however, as most will prefer this plan to straight bankruptcy. So, continued. The amount that you will pay to the court each month is determined by your salary and the amount of wages left over after normal monthly bills such as food, utilities, transportation, clothing, and entertainment. The best part of this plan is that it can be filed without an attorney. The procedure for filing a wage earners plan is as follows. Go to the nearest United States District Court and ask for the official in charge of such proceedings. You must fill out about 5 forms on which you list your income and your debts. A filing fee of $20 is usual in most states. A $15 court fee is also required at some time during the proceedings. Almost immediately, a restraining order is sent to all your creditors. The restraining order, will forbid creditors or their agents from harassing or threatening you, cease immediately all charges of interest on and late payments, terminate any and all legal action brought against you. Another benefit of this plan is a 3-month grace period between the date of filing and your court date time, in which no payments at all are required of you. Other advantages are your credit reputation remains intact and payments can be made at time intervals of your choosing, whether they be weekly, monthly, or bi-monthly. Every creditor who is owed must file a claim within 6 months. Should a creditor fail to file a claim for payment under the wage earners plan, he is barred from ever filing a claim and the debtor will be discharged of the obligation. So, let's keep it moving. Bankruptcy, the ultimate. This should be your last resort. Despite the increasing incidence of this course of action, many people, ignorant of alternatives, resort to bankruptcy unnecessarily. They let their creditors push them into a corner. They then feel there is no escape except bankruptcy. Unhappily, bankruptcy is the only way out of debt in some cases. Bankruptcy is made available to debtors as a way to resolve debts they cannot pay. Creditors, on the other hand, are allowed to share in the assets of the debtor. After filing, all of your possessions, your assets, and your debts are, in effect, now the property of the court. Everything you own and everything you owe is taken by the court. The court, however, gives you back certain property. Exempt items are determined by state law. The best of this situation is that most of your personal property is exempt in virtually all states. Exempt property includes your house, if homesteaded, clothing, necessary furniture, etc. Property that is not exempt is divided among your creditors, but in 90% of all bankruptcy cases, the debtor pays less than $100 of his assets to the creditors. In fact, 75% of the debtors who file bankruptcy pay absolutely nothing in reimbursement to their creditors. Bankruptcy is not foolproof, however. Some debts are not dischargeable under this procedure. These non-dischargeable debts are taxes, alimony, child support, debts resulting from intentional injury to persons, damages to property, and debts obtained through fraud. Continued. After considering the pros and cons of bankruptcy and deciding it is suitable for you, you will find that it is a relatively simple procedure. Stop by a stationery store and purchase a set of bankruptcy papers. Fill them out, they're pretty self-explanatory, making sure that you list all your debts. Anyone you miss on the list may still sue you for payment. Now, list your assets and take papers to the proper court official to file them. There will be a small court fee. In about 60 days, you will be called to a hearing. Explain to the court official that you are not represented by counsel because you are broke and can't afford it. Usually, the proceeding can be carried on without an attorney. If your affairs are unusually complicated, it may be necessary for you to obtain legal help. However, assuming that your affairs are in decent order, bankruptcy will be affirmed after a short hearing. Here are some closing thoughts about bankruptcy and its meaning to you. Contrary to belief, a person who has filed for bankruptcy can get credit. Since anyone awarded bankruptcy cannot file again for 6 years, he or she is usually a better credit risk than some others might be. As mentioned before, bankrupts rarely lose any of their property as a result of this action. In fact, many bankrupts do not list all assets. Also, even if you file for bankruptcy, you can still pay off selected creditors such as a car loan or similar accounts. So guys, this is the end of the video. I hope you guys enjoyed that. I hope you guys found some value in that. There's a bunch of information in here that could help you with your particular situation. So go back through, watch it again, screenshot anything you need, and do further research and due diligence on these things. And if you need to, seek legal counsel, because once again, I'm not a lawyer, I'm not an attorney, and this is for education and entertainment purposes only, guys. So once again, I want to thank you guys for watching. If you enjoyed it, go ahead, smash the like button, tap the subscribe button, leave me a comment in the comment section below. Let me know if you want me to go further in depth on something. And also go ahead and check out the other videos on my channel where I talk about how to make money with cryptocurrency. I talk about how to fix your credit, financial markets, a bunch of cool information like I have in this video. If this interested you, I'm pretty sure those other videos will interest you as well. So go ahead, head on over to the playlist section and they will be nice and organized for you there. And as always, my friends, I want to thank you once again and send infinite abundance to you now and forever. I will see you again in the video tomorrow. Peace.